David Walker enters this Kansas courtroom with 2 active criminal cases, 2 missed court appearances, and a combined $16,000 in newly imposed bonds. But instead of focusing on the bench warrants or preparing for the serious charges against him, Walker is about to steer the hearing into a familiar and legally dangerous argument. If there is no individual victim, how can there be a crime? Walker is facing allegations that include possession of methamphetamine, possession of drug paraphernalia, and driving with a suspended license. He has also decided to represent himself, even though the judge repeatedly explains that an attorney could be appointed at no cost if he cannot afford one. That decision becomes increasingly important when the court discovers there may be no properly documented waiver of counsel in the file. The judge attempts to protect Walker's constitutional rights by confirming his decision and asking him to sign a written waiver. But Walker turns that routine safeguard into a debate over whether the state of Kansas has the authority to prosecute him at all. Watch closely, because the judge gives him multiple opportunities to accept legal representation, understand the paperwork, and concentrate on his upcoming hearings. Instead, Walker keeps returning to the same no victim argument until the judge finally shuts the discussion down. Is he asking a genuine legal question, or attempting to derail the proceeding with an argument that cannot defeat the charges?
Good afternoon. Your name, sir?
David Walker.
Yeah, it looks like he has 2 files.
I see that. All right, we'll next take up 2 cases, both entitled State of Kansas versus David Wayne Walker, 22 CR 398 and 22 CR 508. All right, we'll first take up 22 CR 508. This is my case, Mr. Walker. You failed to appear in front of me on July 17th for your preliminary hearing control docket. Where were you that day?
Say for sure, sir.
Okay, well, I issued a bench warrant bond forfeiture and set a new bond in the amount of $10,000 cash or surety. Are you still representing yourself?
Yes, sir.
Do you want to continue representing yourself?
Look at me. I'm not looking at you. I'm looking at the paper. Yes, sir. Don't have any money to.
Pardon?
Yes, I guess I'll represent myself.
Okay. You understand that if you can't afford to hire an attorney, one would be appointed for you.
This paperwork is not a meaningless courtroom formality. Walker has a right to legal representation, but he also has a right to represent himself if his decision is made knowingly and intelligently. The problem is that the court's records apparently do not contain a signed waiver or a clear earlier waiver made on the record. Saying that you intend to hire an attorney is not necessarily the same as formally giving up your right to counsel. That is why the judge repeatedly explains Walker's options and asks for written documentation. The waiver protects Walker by confirming that he understands an attorney could provide legal advice, identify possible defenses, challenge evidence, and guide him through procedural requirements. It also creates a record showing that the judge did not simply force him to proceed alone. Walker's statement that he does not know what an attorney would do for him is particularly concerning. Self-representation may sound empowering, but a defendant must follow the same procedural and evidentiary rules that apply to trained lawyers. Would you ever represent yourself while facing multiple criminal charges, or would you accept an appointed attorney?
I don't know what he would do for me.
Okay. Well, he could provide you legal advice and perhaps advance any defenses you may have had, but if you want to represent yourself, you have that right. I just want to make sure you understand that if you can't afford an attorney and would like to have one represented you, I would appoint one for you. Do you understand that?
Yes, sir.
And you wish to continue representing yourself?
Yes, sir.
The docket notes don't reflect if a waiver of counsel was ever signed. Do you have any notes that would reflect that He's waived counsel on the record or otherwise, Ms. Norris?
Your Honor, I just note that on December 30th of 2022, defendant stated that he would hire his own counsel, and then he had a failure to appear. And on May 5th, we did not appoint any counsel. I don't show an actual waiver. And the notes don't reflect that he did a waiver on the record. It just says that he would hire his own attorney.
And this is where Walker's argument runs directly into criminal law. A criminal prosecution does not always require an identifiable private individual who suffered physical injury or financial loss. The government can prohibit conduct it determines threatens public safety, public order, or community welfare. That is why offences such as drug possession and driving with a suspended license can be prosecuted by the state even when no private citizen appears in court claiming personal harm. Walker repeatedly asks who the victim is, but that question does not resolve whether the charged conduct violated Kansas law. More importantly, this hearing is not the trial. The judge is trying to determine counsel status, address Walker's missed appearance, preserve his rights, and schedule the case. Any legal challenge to the charges would need to be raised through the correct motion and supported by valid legal authority, not simply repeated during an unrelated discussion about waiving counsel. The irony is hard to miss. Walker is asking for access to legal materials while simultaneously declining the appointed lawyer who could analyze those exact issues for him. Is this genuine confusion, or is he using the no victim claim to avoid answering the judge's straightforward question?
Okay. Well, Mr. Walker, you've indicated here on the record that you wish to waive your right to an attorney and represent yourself. So I'm going to have you, if the jail has one, sign a waiver of counsel. Do you have a form?
I believe so.
All right. Can you read through that? Make sure you understand it. If you have any questions, be sure to ask me.
There is no defendant in the. I'm the defendant in the case. Am I the defendant in the case? There's no victim. There's no victim to my crime. Correct. The crime that I'm accused of. There is no victim in the crime.
The state of Kansas, you have drug charges: possession of methamphetamine, possession of paraphernalia, and driving while suspended are your three charges.
Yeah, but no victim, correct? No victim in the crime? No victim?
I'm not sure I understand your question and what that has to do with your waiver of counsel.
Well, I'm the defendant. There must be someone making a claim that
The state of Kansas is making the charges against you, Mr. Walker.
The state of Kansas is the victim.
The state of Kansas charged you with these crimes. Do you wish to represent yourself, or do you wish to have an attorney representing you?
I will represent myself.
You've got a waiver of counsel in front of you, correct?
Yes, I suppose so. Why do I need to sign? Why do I need to sign it? Why do I need to sign this?
Because I like to have it documented in the file that you understand that you have a right to have an attorney representing you, and that if you can't afford to hire one, one would be appointed for you. And you understand that, and knowing those rights, you wish to represent yourself. That just documents that for the court file.
What I don't understand is why there is charges against me when there is no victim.
All right, Mr. Walker, I'm not going to play this game this afternoon. I'm going to set this case
Why are we playing a game?
in front of me on
I'm asking questions. I'm really
October.
trying to understand.
Mr. Walker, your case is being set on October 10th at 2:30 in front of myself, and that will be done by Zoom. That's the felony preliminary hearing control docket, October 10th at 2:30.
Your Honor.
You got a $10,000 cash or surety bond on that case.
Yeah. I was wondering if I would be, if I wouldn't be able to have access to certain legal things to be able to put my case up.
I believe they've got a law library there at the jail. I'm not sure what kind of access they provide to you, but you can consult with somebody there at the jail.
Okay.
All right, I'm now going to take up 22 CR 398. This is Judge Webster's case. Looks like you failed to appear in front of her on July 31st. She set a new bond for $6,000 cash or surety. You've already had a first appearance, so I'm going to set this in front of Judge Webster on October 30th at 9 o'clock in the morning. That will be by Zoom, October 30th at 9 o'clock in the morning. So again, your bond is $6,000 cash or surety. Anything else on this case, Ms. Norris?
No, Your Honor, thank you.
Your Honor, was the time for court on October 10th for 22 CR 508, was that 2:30?
That's correct.
Just clarifying. Thank you, Your Honor.
All right, we'll be in recess. Mr. Walker, you are excused. Thank you.
This hearing ends without any trial, dismissal, guilty finding, or final ruling on the underlying charges. Instead, the court addresses David Walker's failure to appear, his decision to represent himself, his access to legal resources, his bonds, and the scheduling of both pending cases. In Case 22CR508, Walker's missed July 17th appearance resulted in a bench warrant, bond forfeiture, and a new $10,000 cash or surety bond. That case, involving allegations of methamphetamine possession, paraphernalia possession, and driving while suspended, is scheduled for the Felony Preliminary Hearing Control docket on October 10th at 2:30 by Zoom. In Case 22CR398, the court notes another missed appearance before Judge Webster on July 31st. A separate $6,000 cash or surety bond remains in that matter, which is scheduled before Judge Webster on October 30th at 9 a.m. by Zoom. Together, the two bonds total $16,000, but they remain separate obligations connected to separate files. The major takeaway is simple. Walker may represent himself after a valid waiver, but doing so does not change the charges, erase the missed appearances, or convert the no victim argument into an automatic defense. Do you think the judge showed enough patience? Or should the court have insisted that Walker consult an attorney before proceeding? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.